Mr. Bove, on the eve of your hearing, we witnessed a coordinated political attack in the media claiming that you advocated disobeying court orders. Never mind the hypocrisy we have from the other side. 2 days ago, a left-wing Biden judge said he would defy a Supreme Court order. All the Democrats on the committee voted for that judge and don't seem to be concerned about his decision. There are serious reasons to question the legitimacy of these allegations against you. This initial unconfirmed whistleblower report was leaked to the media, and the Justice Department was only given 15 minutes to respond to the story. The Deputy Attorney General has unequivocally publicly denied the allegations, and indeed the alleged whistleblower previously signed a brief affirming the Justice Department did not violate court orders in its use of the Alien Enemies Act. I want to hear from you directly. How do you respond to these allegations? And did you ever advise the Department of Justice to defy court order?
So to get to the last part of that question first, Chairman, no, I have never advised a Department of Justice attorney to violate a court order. And if I could elaborate a little bit. I'm respectful of the whistleblower process. And I understand that there's protections in place around that, and also that there are valid contributions made to good government through that process. I don't want to disparage that whistleblower in this proceeding, but I also have to address, to some extent, the allegations. As you noted at the outset, I'm also bound by privileges that the whistleblower did not consider himself bound with in leaking that report to this committee just yesterday. But there are a few things I'd like to say and confirm. I will reiterate, I did not advise any Justice Department attorney to violate court orders. The Deputy Attorney General, as you made clear in your opening remarks, Chairman, has confirmed that the account in that whistleblower complaint is not accurate. But even if that account is taken at face value, the whistleblower acknowledges that he left the meeting on March 14th of this year with the understanding that, of course, the department would advise clients to abide by court orders. And then, as you noted, the whistleblower signed a brief filed in the District of Columbia just weeks later, explaining all the legal reasons that in the JGG case, the department and the parties, the department and the parties the department represented had complied with court orders. And so for all those reasons, I don't think there's any validity to the suggestion that that whistleblower complaint filed yesterday calls into question my qualifications to serve as a circuit judge. I also think what's clear in the 3 cases that the whistleblower accounts for is that this is fundamentally a dispute about the challenges posed by the unelected bureaucracy to the unitary executive and to the people that elected the president and put him in office. And what I mean by that is throughout this complaint, there's a suggestion that a line attorney, not even the head of the Office of Immigration Litigation, was in a position or considered himself to be to bind the department's leadership and other cabinet officials. I don't abide that line of thinking in my management style, and I'm not apologetic of that.
I'm going to not give my lead into this question, but how do you respond to the criticisms you received regarding Mayor Adams' case? I'm not describing the case, but you know what I'm talking about.
I do, Chairman, thank you. I think that this answer has to start with the fact that the motion to dismiss those charges was granted, and it was granted after the ethics complaints that were referenced earlier today. It was granted because the motion reflected a valid exercise of prosecutorial discretion. Now, there's been some criticism, including this morning, suggesting that there was some kind of illicit quid pro quo in connection with that motion. That's simply false, and it's refuted by the record. Mayor Adams' lawyers filed a letter on the public docket in that case that stated explicitly there was no quid pro quo. One of those lawyers, and they're both respected members of the bar, stood up in court at a hearing in the case and said the same thing. And then critically, Mayor Adams himself was sworn under oath at the hearing, and he explained there were no agreements outside of what was committed to writing. And so the suggestion that there was some kind of quid pro quo is just plain false. There's also been criticism about the department's decision to seek dismissal without prejudice in the motion that we filed. That decision was made for two reasons. First of all, dismissal without prejudice is the default under the applicable rule. That would have happened. It's a normal course in any case. In addition, with respect to Mayor Adams, a dismissal without prejudice would have allowed the permanent U.S. attorney to reevaluate the case without the weaponization concerns that the department had, without the risk of interfering with the ongoing mayoral election, and without the need to interfere with Mayor Adams' governance of the city after that election took place. Those were the considerations that drove the determination to seek dismissal without prejudice. And Judge Ho's decision to proceed on another path by dismissing the case with prejudice certainly does not call into question my ethics or my decision-making. It's a legal difference of opinion. Thank you.
Senator Durbin.